Yes.
But I like to get a mention to item number 10.
Item number 10.
Yes, with the consent of the other side. Can the may I pray
So
for
we have to take only first stage. Three states you haven't taken probably.
They have already appeared. They have already
They've
appeared.
already appeared.
Yes. On the last occasion, the last date,
They've already appeared. Okay.
instead of the others council.
You are Mr.
K. Saxena.
K. Saxena.
Yes.
Mr. K. Saxena, learned counsel, appears the petitioner.
Yes.
With the consent of the other side, he seeks 3 weeks as adjournment of the matter. Other side's counsel doesn't have any objection to that. Prayer is allowed. Release the matter after 3 weeks.
Right.
You are Mr.
No, I'm not. I've taken
You are not.
May
Okay.
Your Lordship.
Yes.
May Your Lordship. I think
Yes.
item number 16 of today's case, Your Lordship. Item number 16. I'm for the petitioner, Your Lordship. Kindly may be taken after 2 weeks, Your Honor. Your Lordship. In this case, we have taken already steps upon the respond number 2. And today I am having some personal difficulty. So kindly may be taken after 2 weeks, Your Honor.
You have taken the consent of the other side? No.
And there is no means there is a state council. The other the respond number 2 has not been appeared.
Lordship, the PP is there.
Yes, I don't have any objection.
Okay. You are Mr.
Himanku Borua.
Mr. H. Borua, learned counsel for the petitioner, appears, and he prays for adjournment of the matter for 2 weeks. The prayer is allowed. Release the matter after 2 weeks.
Yeah, Your Lordship. Your Lordship, I beg to mention item number 3, Your Lordship. Here I am for respondent number 1, Your Lordship. We are yet to file our affidavit in opposition, Your Lordship.
The government advocate.
Yes, Your Lordship. So
You are Mr.
Waireram.
Y. Redam, learned government advocate, appears on behalf of the respondent number 1.
1, yeah.
Respondent number 1, and he prays for adjournment of the matter to file an affidavit, file the written objection.
Yes, Your Lordship.
File the written objection in the matter. Prayer is allowed. Release the matter after 2 weeks.
My lord, I am appearing for the petitioner, my lord.
Yeah, Mr.
M. Ratan,
Please write his name. Learned counsel appears for the petition.
petitioner. My lord, interim is there. Interim, my lord.
Interim order passed earlier will continue to the next date. Release the matter after 2 weeks.
Deeply blessed.
And Your Lordship, item number 11. I've already taken the consent of the applicant, Your
Okay,
Lordship.
learned government advocate, Mr. So-and-so, learned government advocate appearing on behalf of the respondent submits that he has already taken consent of the other side and prays for accommodation of 2 weeks.
After a week, Your Lordship.
Prays for an accommodation prays for an accommodation of 1 week. The prayer is allowed. Release the matter after 1 week.
And Your Lordship, item number 18 as well, Your Lordship.
I don't know, 8 also.
1/8, Your Lordship. 18.
18.
Yes, Your Lordship. This may also be,
This is a hearing matter.
yes, Your Lordship.
Why are you not doing this?
I'm making this on behalf of Mr. S. Tapin, Your Lordship.
As Tapin,
Yes, Your Lordship.
he's not around.
No, due to some personal, he had to leave court premises, Your Lordship.
Mr. So-and-so, learned counsel, appearing on behalf of Mr. S. Tapin, senior government advocate. He submits that due to some personal difficulties, S. Tapin is not in a position to appear in the matter today and prays for how much time?
After a week, Your Lordship.
Prays for a week's time. Prayer is allowed. Release the matter after a week.
Obliged.
My lord, may I beg to mention item number 19, my lord?
This is also a hearing matter.
Yes, my lord, but this year is not received. This year. Today's this year is
hasn't received.
not received, my lord.
You are appearing for?
For the state, my lord, SIT.
You are special PP.
Yes, my lord.
What's your name?
El Kurdu, my lord.
El?
El Kurdu. El Kurdu.
Mr. So and so, special PP, appearing on behalf of the petitioner, and he submits that PCR in the instant matter hasn't been received as yet. Accordingly, he prays for a week's time, or how much
My lord,
time?
28, maybe fix on 28, my lord, with the consent of other party, my lord.
He prays for the matter to be listed on 28
28.
August. Prayer is allowed. Let this matter be listed on 28 August.
Obliged.
I'd like to mention the item number 8.
Item number 8.
Yes.
What happened in 8?
My lord, I have taken the consent from the other party. The matter may be listed after 3 weeks so that the respondent can file the affidavit in opposition.
You are Mr.
T. Role.
T.
Role.
Your name is not there in the cause list?
Yes, ma'am. Actually, I have only instructed to mention the matter.
Who is appearing in the matter otherwise?
My senior counsel, L. Paramet.
Leasing permit, Your Lordship. Leasing permit. L permit, Your Lordship. Yes. Your Lordship, is this interim order may be continued, Your Lordship. Matter may be listed after 2 weeks, Your Lordship.
Mr. So and so learned counsel appearing on behalf of Mr.
Service, Your Lordship, in this matter, service has been completed, Your Lordship.
Service
Service.
completed.
Yes, sir.
Yes, service completed. Wakalan now filed. No? I mean,
Yes.
respondents have filed the wakalan now. So, Mr. So and so learned counsel appearing on behalf of Mr. L. Perme, learned counsel appearing for the respondent number
1 and 2.
respondent number 1 and 2, appearing for the respondents. He plays for 2 weeks time.
3 weeks, Your Lordship.
2 weeks will do.
My lord,
Okay, he plays for 3 weeks time. He plays for adjournment of the matter for 3 weeks. Learned counsel, so who?
T. Ango, Your Lordship. I am the petitioner, Your Lordship.
Appearing for the petitioner, learned counsel appearing for the petitioner does not have any objection to the prayer made by the counsel for the respondent. Prayer is allowed. List this matter after 3 weeks.
All right.
I may be allowed to know 4 numbers of electric arising out of same place.
Today,
Today.
unlisted matter.
Yes.
Okay, no. So it will be taken after a list or what? How do you take it? How do you take it? Usually unlisted matters. Last time.
May I please, Your Lordship? Lordship, I beg to mention item number 9, Lordship.
Item number 9.
Nine,
What happened?
Lordship, in this matter, in the earlier occasion, Lordship, when the sole respondent's address was incorrect, Lordship, we have been instructed by this
So
order.
you haven't taken the fresh tapes as yet.
Yes, Lordship, but I have just gone through with the records and since the service has not been taken by my colleague, Lordship. So I may be allowed to take a fresh step within today itself. I'll take it.
You are Mr.
T. Garam, Lordship.
T. Garam.
Lordship.
Mr. T. Garam, learned counsel, appears for the petitioner, and he prays for. I'll give you 1 week time.
Lordship.
He prays for 1 week time to take fresh steps in the fresh steps for service of this service of notice in the instant case. Prayer is allowed. List it after a week.
Lordship.
Anything else?
Lordship, there's the interim order that
Or the interim order so passed earlier will continue till the next date.
deeply applied.
Your Lordship, I take in item number 14. Lordship, I am for the petitioner in this case. Lordship, the matter may be adjourned for filing of additional activity.
Earlier also you have taken time.
Yes.
Why? Why you haven't
Since
filed?
the petitioner is out of station, that's why we are unable to file that day.
You are appearing for?
Appearing for petitioner.
Yeah. Mr. MS so and so, learned counsel appearing for the petitioner and praise for 1 week time. 1 week's time to file an additional affidavit in the matter. Where is allowed, list the matter after a week.
There is an interim, your lordship.
The interim order so passed earlier will continue till the next.
Item number 1.
Yes.
Lordship, this is application filed under section 528 of the BNX and my lord. For quashing of the my lord criminal proceeding, being my lord,
Yes.
conducted in the court of judicial magistrate UP, my lord. In fact,
Yes.
my lord, the fact of the case is that, my lord, the petitioner, my lord, in the year 2006, my lord, there was a election of Itanagar Market Welfare Society, my lord. Petitioner, he is one of the aspirants, my lord,
Yes.
for the post of general secretary.
Yes.
And apart from him, my lord, there were 2 other candidates, my lord.
Yes.
However, there is the faithful day, my lord, this post FIR, my lord, it was in fact, my lord, filed by, it was not filed by the complainant, my lord. It was given the statement before the trial court, my lord. However, my lord, the opposite party, my lord, has conspired against the petitioner, my lord, so that it cannot stand in the election process, my lord.
So was there any record was supposed to be received here?
No, my lord, perhaps record has been received, my lord.
Now here, I mean, there was an order here, 11/8/2025. We have a look on that. Yeah, Mr. Ite,
Yes, my lord.
you have a look on,
Yes, I will
you
check
be
the-
having,
yes, my lord.
please
Last
check,
report.
please check. If you have the record of the order. See, it says, like Mr. Ite, learned public prosecutor submits the records of the case is yet to be transmitted from UPR.
Yes, my lord. That is
Therefore, place
TCR,
for list-
trial court. I was make submission on trial court record, my lord.
Yes.
It's reflected in the cause lead with TCR, my lord.
TCR received.
Yes,
But
my
it
lord.
was, but in the last order, it was not there. 11/8/2025. The original affidavit. Probably it was there only last date also. Yeah, yes, you can carry on.
May I continue, my lord?
Yes, you continue.
My lord, on 19/7/2006, my lord, as there was a conspiracy against me, so that I am debarred from the election process of the Market Welfare Society, my lord. Of the
You are Mr.
Mr. My lord, Lokam Talon, my lord.
Come, okay.
Yes, my lord. As submitted, my lord, I was one of the candidates, my lord, for the
Yes.
post of General Secretary, my lord.
Mm-hmm.
In the meantime, my lord, there was a conference held by opposite party, my lord. And to execute that, my lord, they have engaged 3 persons, my lord, who went to the shop of the complainant, my lord, and had forcefully obtained the signature of the complainant, my lord, without disclosing the contents of the paper, my lord.
Without disclosing the contents of the document.
Yes, my lord.
Okay.
So thereafter, my lord, they 3 persons, my lord, after obtaining the signature of the complainant, my lord, they went to the police.
Who are those 3 persons?
Those 3 persons, my lord, it was not disclosed, my lord. But the complainant, my lord, is
Yes.
unambiguously stated in the trial court that there were 3 persons came to his shop and obtained the signature.
So 3 persons, they are unknown.
They were unknown.
They are unknown
They,
persons.
they were not familiar to the complainant, my lord.
They were not familiar to the
Yes.
complainant.
Yes, my lord.
And what about the petitioner?
But
They are known to the petitioner?
no, my lord. Even petitioner do not know, my lord, who were they, my lord. Because petitioner did not see them, my lord. So therefore,
But the allegation is that on behalf of you, they have gone there. allegation is that on behalf of this petitioner, they have gone there and collected the signature.
Yes, my lord, not on behalf of the petitioner, my lord.
Mm.
My lord, as I have submitted, my lord,
Mm.
apart from my lord, the petitioner, there were two more candidates for the post of general secretary.
Mm.
So these, we have a doubt, my lord, these people, the other two candidates.
People may have engaged them,
Yeah,
may have
but
engaged them,
This person, my lord.
may have engaged them and asked them to go there
Yes, my lord.
and get the documents signed.
Yes, my lord.
Yes.
After that, after obtaining the signature of the complainant, my lord, that was of course forceful, and they lodged the affair before the Eternal Police Station, my lord.
Mm.
On my lord, 19/7/2006, my lord. Thereafter, my lord, charges was filed on 6/3/2008, my lord.
Where is the FIR?
FIR, my lord.
Page 25,
Page number 16, my lord.
page number?
15, my lord. And 16 is the type copy, my lord. And lecture 2, my lord.
But here somebody is named in the FIR.
Yes, my lord. It's in the FIR, my lord. It has been alleged that, my lord, the petitioner, my lord,
Hmm.
has come to the shop of the complainant, my lord.
Hmm.
But this is not the true version of the this, my lord, story, my lord.
How do you say so?
My lord, therefore, my lord,
Then after the FIR, where is the charge sheet?
charge sheet is, my lord, the page number, my lord, 70. It starts from 70 to 98.
You read the charge sheet. Type copy at page 21.
The great prosecution is the case that on 19/7/2006 at 18:30 hours, the written complaint received at Eternal PS from one Sri Anik Chandra Thor. Date of so and so, Atak Big Ganga Eternal to the effect that one Sri Lokampala took his small arm, came to him last 20 days back and demanded him rupees 1,500. Only in order to purchase petrol. Out of fear, he paid said amount. And again on 19/7/2006 at 10:30 hours, Sri Lokantala came to him by Maruti car and demanded to pay him cash amount of rupees 50,000 only in favor of NSCN within 23/7/2006 and threatened the case threatened to face consequences if failed to fulfill his demand. Hence, the case in receiver of the above complaint, a case registered by Kita PS case number 126/2006 under section 384/506 IPC review section 25B small a 27 Arms Act and endorsed my name for investigation, and I have investigated the case. During the course of investigation, the PO was visited, examined the complainant along with other available witness and recorded their statement. The alleged accused Lokantalo, who was already been arrested in connection with Eternal case number so and so, read with Amset, has been shown arrested in this instant case. The Maruti car bearing number so and so used by the alleged accused while committing the offense have been seized by the IO in connection with Eternal case number 125/2006. reviewed arms act. The Xerox copy of seizure memo of which are enclosed here in separate sheet. During the course of investigation, the accused Lokantalo pleaded guilty of committing extortion in various scope of Itanagara, including in this instant case by showing a firearm who has already been seized by the IO of the case number 125/2006. Reviewed arms act, which a Xerox copy of seizure list is enclosed. However, as per confessional statement of the accused Lokantalo, he denied that he was received firearms from one Sri Yumla Achung. Instead, he got the firearms which was buried by a Kochari boy whose address is not known. Therefore, Sri Yumla Achung, who was arrested in the instant case, may be discharged from all his liabilities. The prayer for prosecution sanction has already been submitted to district magistrate. Hence, Honorable Court is prayed to process may be initiated. Hence, under the above facts and circumstances, a prima facie case under section 384, 506 IPC, reduced section 125, capital B, capital small a 27, arms act is well established against accused Lokantalo for intention of screening himself, committing extortion, and threatening to complainant and illegal possessions of carried firearms and ammunition. Under the aforesaid section, beg cushion him to stand trial in the Honorable Court. The witness mentioned in serial number 13 may be summoned to the court to prove the case after fixing the date and time of hearing.
What happened to the other case?
My lord, in the other case also, my lord, that was kind of same, my lord, conspiracy, my lord. And for that, my lord, the petitioner, he has, my lord, filed this application under.
No, there are two cases, right? One,
Yes,
one is the
yes,
instant
my lord.
case, the earlier also one case.
In that case also, my lord, that case also has been, my lord, quashed by this Honorable Court.
But you have filed an application for that.
Yes, my lord. It has already been quashed, my lord. That other case, my lord,
And that is
125, which,
already been,
yes, quashed by this Honorable Court, my lord.
where is the order?
Order, my lord, we have not annexed, my lord.
We should get that order, where if it is similar matter, and like similar accusations, similar sections are there, and that matter has been passed.
It was settlement matter, my lord. This is on merit, my lord.
Yes, that was on settlement, my lord.
But still the order should have, you should have placed the order.
My lord, that order can be placed, my lord. We can have that order.
You can place it today.
Yes, my lord, we can obtain the CTC right now.
You get that order.
Or else, my lord, it is already uploaded in the website, my lord.
You can get it. Huh?
If,
We will take up this matter after some time.
yes, my lord. Then, my lord, in that case, my lord, CTC might take time, my lord. Can we produce this, my lord, this uploaded?
My lord, I have this order copy in detail.
Give it to him, he'll give you a print
Yeah.
out.
Yes, your lord.
Give a print out, give it to him.
There also, your lordship, we raise an objection, your lordship, and that case also. Even if joint petition, your lordship, the issue there was, your lordship allow. Your lordship, the FIR disclosed the commission of cognizable offense. And now, your lordship, the law is very well settled that if on the face value of the FIR, if it does not disclose any cognizable offense, then no doubt, your lordship, in exercise of 528, your lordship, corresponding to 482, the court can quash the matter, your lordship, in light of the Bhajanlal matter, my lord. But however, your lordship, if FIR disclose commission of cognizable offense, subsequently, your lordship, after conclusion of the investigation, even if the charge sheet disclose, your lordship, that there is a material of the commission of the cognizable offense. Whether the subsequent proceeding, which was before the trial court, whether that can be quashed or not, on that aspect, your lordship, we have raised an objection there, your lordship. However, your lordship, considering the statement of the PWs, your lordship, this honorable court was pleased to quash the matter, and it was not subjected to challenge before any authority, my lord. That is the fact of that case, your lordship. However, in this case, your lordship, there is no any settlement. In that case, settlement was taken into consideration.
Yeah, but they have filed in
But that's the wife, my lord, wife of the victim, my lord.
but the complaint is already, he is already expired.
Yes, expired, your lordship, but it will not await him, your lordship. It should be the accused person, your lordship, for awaiting the proceeding, your lordship.
The complainant is the victim, right?
Yes, your lordship.
So victim is already expired,
Yes, your lordship.
and his wife files an affidavit.
And that too during the pendency of this case.
Dependency of the matter,
Yes, your lord.
stating that she doesn't have any objection in
Yes,
settling
Your
the matter.
Yes, your lord.
In that situation, what is the law?
Now, your lordship, the question here is, my lord, the Arms Act is there. And arms act, your lordship, no doubt sanction was not there in the, since there was a want of sanction, the learned trial court was not charged him under the arms act section, yes. But your lordship has already seen the charge sheet, your lordship. It clearly says the arm was recovered, seized, and it is there. If it is not a case where arms was
Charge sheeted on that offense.
charge sheeted for arms act also, my lord. But charge not framed.
Yes,
Charge not framed because of the want of sanction under section 39 of the Arms Act, my lord. So now, your lordship, the question here is, if FIR disclose commission of cognizable offense and subsequently charge sheet also, whether the statement of the victim who has turned hostile, my lord, basing on that, whether it will have a reverse effect on the FIR, whether it will make the FIR, the correctness of the FIR can be ascertained from that statement, your lordship. That has to be looked into, because now the trial has already proceeded. And the conclusion would be either conviction or the acquittal, my lord. But so far as the law is concerned regarding, your lordship, quashing, he has, if there is no case made against him, if prosecution failed to prove the case against him, then he will come unscratched. He will be acquitted. But whether at this stage, all this plea, whichever he has taken right now, your lordship, that he has been falsely implicated, all this can be taken up at this stage. In my humble understanding, no. Because this court cannot conduct mini trial, my lord. And so far as correctness of FIR, your lordship, even the correctness of FIR cannot be looked into by this court in exercise of power under 528. If it is disclosed commission of cognizable offense, and subsequently it has been, your lordship, confirmed by the material so collected, and cognizance has been taken on against the offense, not the offender, but it is now the charge has been framed to try the offender, actual offender, who has actually committed the offense. So now, your lordship, for their convenience, how they, if the other side has turned hostile, and as on that, your lordship, if we see the record, it seems like, your lordship, there is a fair chance of acquittal. However, whether there is any law which says that in trial, if there is a fair chance of succeeding the trial, whether the court can exercise 528 or the corresponding 482, I have not come across such judgment, my lord. But the law is very clear. If cognizable offense has been disclosed, material collected, trial commenced, even if turned hostile, or even if there is a case.
And that settlement was made by the complainant at the time he was alive. Or what?
No, your lordship. The complainant was dead. Wife entered into.
That case,
Yes.
wife and the accused.
Yes, your lordship.
They have come to a settlement.
Yes, and that too, your lordship, when this petition was pending, they have entered into an agreement.
1 second. In that case, the informant, victim and accused have jointly filed.
Yes, madam.
Jointly filed.
In that case,
filed
madam.
in that case.
Yes, madam.
That's a different case.
But, yes, my lord. But then, my lord, since, my lord, all the affair, my lord, it was executed by the conspiracy heads by my opponents, my lord. So therefore, my lord, since the trial of this case is also, my lord, going on, my lord, and the evidence of the complainant and some other PWDs has been, my lord, taken by the trial court, my lord. In their statement, my lord.
Yes, let him argue, then like
Yes, yes.
I'll hear you.
Yeah.
Yeah, I've gone through this. Yeah, yes.
My lord, thereafter, my lord,
Yeah, charge sheet was filed
Yeah.
and
then thereafter, my lord,
then trial happened.
Trial
What happened in the
started, my
trial?
lord, and it is now at the stage of PW, my lord, prosecution witness, my lord. And
What is this page 25? 25 is statement of the complainant.
page 25 is the statement of the complainant, my lord. Page 25 is the type copy, my lord.
These are all 161.
Yes, this is 161, my lord. Now, my lord,
I mean, trial is at what stage now?
prosecution witnesses, my lord. And my lord, So far, my lord, the evidence of complainant and some this prosecution witnesses has been, my lord, taken by
Examined,
the
they
trial
have
court.
been examined. Where,
Yes,
where,
and then, my lord,
where are those?
my lord, may kindly come to page number 100, my lord. 100. This is the, my lord, statement of the complainant, my lord. May I read, my lord?
Hmm.
On,
Yes.
on or, the name is given, my lord, Anil Chandrakar.
Yes.
And my lord, statement on oath is, I cannot recall lodging any complaint against Lokam Tala. The document shown to me marked as P exhibit 1 is not a complaint lodged by me, and P exhibit 1 is my signature. Some boys had come one day and made me sign a piece of paper. Learned APT has submitted that PW1 and the Chandrakar has done hostile contrary to the purpose of the FIR lodged by him and said that he may declare a hostile nature. In view of the prayer made by the learned APP, the reason given and on Procedural of the FIR lodged by the government, that is PW1, PW1 Anil Chandrakar is hereby declaring hostile nature. Now this is the statement.
He has been declared hostile.
Yes, madam.
Now the cross examination part.
Now, it is not a fact that I am lying today in the court out of fear. Question number 1 in the cross examination. In the instant case, where you go to the police station, sorry, yes, in the instant case, I was called to the police station and asked if I can recognize Lokam Tala, and I told police that I do not know him. Question number 2. Are you today lying today before the court that you didn't close the instant FIR in this case wherein you had made complaint that Lokam Tala took it arms came to you and demanded rupees 1,500 and later demanded 50,000? Answer, I am not lying and Lokam Tala did not come to me and make such demand. Question number 3. Did you get your statement recorded before the police in the instant case? Answer, I cannot recall. Now, I will come to page number 101. It is not a fact that I am lying before the court today, since I have the excuse of being an old man and deceased person. It is true that I know Lokam Tala since wants to protect the digital market. The person is standing on the dog Lokam Tala. Now,
1 second, 1 second. So earlier he said he do not know him.
yes, madam.
Then he said that he know him.
Might be, my lord, after the incident, they get familiar to his other mother. He's not given any time, mother, since when he's familiar with Lokam Tala.
Yes.
Now, my lord, page number 102 is also important, madam. This is the statement, my lord, of one of the PW mother. His name is Philip Badut Vishwakarma, madam. And on oath, he has stated that I cannot recall the exact date and year, but one day, several years ago, I have given my Maruti car of debt to Lokam Tala for the 8,000 per month. I cannot recall the vehicle registration number of the same Maruti car several years ago, and I had sold the car. One day, when Lokam Tala was arrested by my ship, Maruti car was also hit by the police. However, I do not know what offense was committed by him. I gave my statement to the police commissioner. I received back my vehicle in demand from police participating on the top with local color. In court, I was not driving the vehicle, which I had given on rent to local color and dropped the state vehicle himself. I cannot say whether my statement under was wrongly recorded by the IO or not. Now, my lord, after filing of this application, my lord, there is a settlement between the wife, my lord, of the complainant and the accused, my lord. And my lord, I have filed, my lord,
Can you legally do it?
it's my lord, it was just to show, my lord, since the petitioner was not at all involved in the
Just read paragraph 2.
my additional affidavit.
Yeah, 104, page 104.
10. Yes, yes. 104, my lord, it is post title, my lord. 105, my lord, paragraph 2.
No, 104 paragraph 2. In my record, it is 104
Paragraph 2, my lord.
paragraph 2.
Yes, madam. Data reported Hamlet summons that on dated 19/3/2025, an application has been executed by the deceased wife, Srimati Saraswati Kaur, stating that she got to know that there is the criminal procedure pending before the fifth judicial magistrate against the deponent arising out of the FIR dated 19/7/2006, filed in the name of her deceased husband. In the said deed of settlement, she has stated and submitted that during the lifetime of her deceased husband, told her that he had never filed the FIR against the deponent. But on his dated 19/7/2006, the unknown person came to his stop and forcefully obtained his signature in paper without explaining the content of the document. Further, it is to be stated that the deceased, where Srimati Saraswati Kaur, in view of the deposition made by the deceased before the chief judicial magistrate, is fully convinced that the deponent has not committed any offence. Therefore, continuing the case would not serve any purpose and would only prolong the case unnecessarily.
Let's go to the affidavit. Let's go to the affidavit, that settlement affidavit, the affidavit, whatever they.
Yes, madam. This is settlement affidavit is page number 107, madam. I, Srimati Saraswati Kaur, wife of late Anil Chandra Kaur, age about 64 years, resident of Ganga Road, Akasmi Ganga Market, Itanagar, district Papur Pare, Arunachal Pradesh, 7910. Wife of the alleged complainant had entered with a mutual settlement that during the lifetime of my deceased husband, that Anil Chandra Kaur, an FIR was filed against Lokam Talo in the name of my deceased husband on dated 19/7/2006 and registered as PS case number. So my husband had told me that he had never filed any FIR against Lokam Talo. On dated 19/7/2006, three unknown person came to his shop and forcefully took the signature of my deceased husband in a paper without explaining the contents of the document. That the trial is pending before the Honorable Court of Chief Judicial Magistrate, hearing case number so and so. In connection with PS case number so and so, and my husband, the alleged complainant, had been examined and he had posed before the court the same thing which was told to me, as told by my husband, deceased husband, and in view of the deposition made before the Honorable Chief Judicial Magistrate by my husband, I am fully convinced that Sri Lokam Talo did not commit the said alleged offence, and continuing the case would not serve any purpose and would only prolong the agony for all parties. Therefore, this mutual settlement has been made in order to declare that the Lokam Talo had never come to the shop of my late husband and had never committed the said offence, alleged offence. Therefore, by this mutual settlement, I being the wife of late Anil Chandra Kaur through her purpose.
Got it. Yeah. Then,
my lord, as my lord, I had submitted my lord. There was no offence as alleged, my lord. No offence was committed by the petition, my lord, as alleged in the FIR. As I had submitted my lord, since there was election of the Itanagar Market Welfare Society matter. And the petitioner had a very good prospect for being elected as the General Secretary of the society matter. So in order to pull his leg, my lord, and in view of the fact that my lord, he has a very good scope. So they have had conspiracy against the petitioner, my lord. And that can be, my lord,
They means other candidates.
other candidates, my lord. Other candidates, other two candidates, my lord. So therefore,
Let us go through the 161 statements.
once you are my lord. Page number 24, my lord.
Come to page 25.
On being examined to reinstated with the court, and a reduced by proposal and running noise of attack with Durban, with another since 1995. On 26, 2006, at around 19:30 hours, once the Lokam Talo due to his small arm gave to my wine shop at the moderate negative 10,000, only in order to cost the petrol at with other expenditure, while getting the new for and out of here I paid him the 1,500. As incorporated by myself in the local cover of the debt to my one subscribe and on taking care of the and for whereabout of me and absolute profit over 4 again on 1976 at around 10:30 hours. Mr. Logan Carlo came to my one step by Marita and took me to corner of my one step and told me that small answer the market to pay in case 50,000 only in favor of earlier within 22 correct deposits and threatened to face consequences if failed to do his demand. So this is matter is the statement under 161. Then, my lord, the statement of 161, my lord.
Hmm?
Statement made before the court, my lord. It is not, my lord.
There is no value 161.
My lord.
There is no value of 161 statement.
Yes, that is there. And even, my lord, there is contradiction, my lord. In, my lord, the charge sheet,
Which is the contradiction?
contradiction is there with the charge sheet, my lord. The IO of the case, my lord.
Hmm.
They say that, my lord, on the first day, he comes and demanded 1,500 rupees, my lord.
Yes.
But the statement of the complainant, my lord, alleged complainant, under 161 says something else, my lord. Says, my lord, he has demanded 10,000.
But he paid 1,500.
Yes, my lord, that is true, my lord. But in any case, my lord, since, my lord, filing of this application is to, my lord, for the end of justice and to prevent the abuse of the process, my lord. My lord has seen, my lord, since, my lord, the complainant, alleged complainant, my lord, he has denied that he has ever filed this complaint against the petitioner.
Yes, yes, yes. Yeah. Done? You have
Yes,
anything
my
else?
lord. That is all my case, my lord.
Yes, sir.
Yes, may it please your lordship. Your lordship, as your lordship has gone through the record, my lord, till the filing of the charge sheet, your lordship, there is no any, your lordship, variation, your lordship, regarding the allegation. And the material so seized, your lordship, the arm is also there in the, it clearly reflected, and the seizure list has also annexed with the charge sheet, which was seized, my lord. However, your lordship, because of the want of sanction under section 39, the accused was not prosecuted under section, the offense under arms act, my lord. But fact remains same, my lord. Same, my lord. The allegation and your lordship, the material so seized, your lordship, during the course of
But it
investigation.
doesn't have any value now.
Your lordship, that,
Charge is not framed against him.
yes, your lordship.
Whatever.
But that is for want of sanction, my lord. And my lord is well aware, my lord. For the other offense, for arm's sake, your lordship, merely because of the during this incidents, different offense operating in different field under which it has been registered. For the offenses where sanction is not required, for that he was prosecuted, your lordship. The prosecuting is going on. But so far as the Arms Act provision sections are concerned, it is not, your lordship. He is not acquitted from that, your lordship, the offense only because of want of sanction. And later on, your lordship, later that may be subjected to the your lordship consideration by the court. However, your lordship, the prosecution is still have time, your lordship. If they obtain the sanction, my lord, the accused can still be prosecuted under the Arms Act, my lord. Because, your lordship,
Where is the provision?
your lordship, this for want of sanction, your lordship. Once, your lordship, the sanction is not there, your lordship, the person will be discharged, not acquitted, my lord. The acquittal and discharge is totally different, my lord. For acquittal, there must be a full-fledged trial, right? But for discharge, like your lordship, want of sanction, the court will will not have jurisdiction to take up the matter. But it doesn't make him. It doesn't result in acquittal of the accused. It's a discharge for the time being, your lordship. But when sanction comes, then again, your lordship, the court will have the jurisdiction to take up the matter and take cognizance
Is
of the matter.
prosecution doing anything in that state?
Your lordship, that part, that is not on the record, your lordship. But they have applied for the sanction. But
They
your
applied for the sanction?
yes, your lordship. Here in the charge sheet, your lordship is also mentioned that.
Where?
My lord, will find in page number 22, second last paragraph, my lord. The prayer for prosecution sanction has already been submitted to the district magistrate. Hence, honorable court is prayed that process may be initiated. This is not the case, your lordship. The police has not filed, the investigation authority has not filed a sanctions for sanction, my lord. And
Okay.
And so far as your lordship sanction is concerned, my lord is well aware of the other provision of the statute or even in the PC Act, my lord. If there is want of sanction, the court special court do not have the jurisdiction to take up that matter. However, when later on if sanction comes, your lordship, if sanction is accorded, your lordship, then the court will have the jurisdiction and will clothe with the power to take up that matter. So here in this case, your lordship, the investigation authority has applied for the sanction. But during the time of taking cognizance, my lord, the sanction was not there. That's why, your lordship, the court has not taken cognizance against this section because section 39 protect the accused from the prosecution under Arms Act for in absence of prosecution sanction. Now, your lordship, the second part is, your lordship.
1 second.
Yeah. Section 39, my lord. May I read?
Yes.
Previous sanction of the district magistrate necessary in certain cases. No prosecution shall be instituted against any person in respect of any offense under section 3 without the previous sanction of the district magistrate. And, your lordship, section provides for, your lordship, the possession and use of firearm without license, my lord.
Yes.
Section 3. License for acquisition and possession of firearm and ammunition.
Which section?
Section 3, my lord, because if
Yeah, section 3, yes.
yes, in contravention of the points. So, my lord, it is clear that at that point of time, he was
Arms were seized.
arms were seized, my lord. And no license, if license was produced, then the section would have been different one, my lord, for violation of the condition of the license, my lord. for which sanction is not required. But this is not the case here. He was possessing the license without.
Without any
Well, yes, my lord. And second, your lordship argument would be, my lord, so for the
So first line of argument is that this sanction is though section 4, though for obtaining the sanction has already been processed,
yes, my lord.
it hasn't been received at a point at the time of taking the
Yes, my lord, yes.
cognizance of the matter.
Yes, my lord.
So this sanction may come anytime.
Yes, my lord. And
Then he can be prosecuted.
for arms act against, yes, against the arms act can be prosecuted because the offenses are operating in the different field. The arms act deal with the and it will not be hit by section Article 20 of the Constitution of India. He will not be considered as prosecuted for same offense because the offense are absolutely different, my lord. And the second line of argument, my lord, is the well-settled law, my lord. At this stage, this is extraordinary, your lordship, inherent power of this court, my lord. Where court find it to prevent the abuse of process and for the ends of justice, where it is indispensable that court should exercise, court interference is required, then only the court should exercise its power, and that too in the exceptional case, my lord. Then exceptional case, your lordship, the parameter has been laid down in the Bhajanlal case, my lord, because this case is on merit, my lord. So, your lordship, firstly the FIR, my lord, whether FIR disclose commission of any cognizable offense or not, my lord. It clearly disclosed, my lord. So, accordingly, investigation was conducted, material were seized, statement were recorded, and so far as the statement is concerned, later on, your lordship, he was turned hostile.
No, I'm only worried with this arms act.
Yes, my lord.
Otherwise, the other offense,
Yes.
and there may be some political rivalry. There was some kind of.
Yes, your lord. That is there. But my lord, my only limited, your lordship, submission to that is whether that aspect can be considered by while considering the 528 application, your
That
lordship.
we can see from the witnesses, we can see from the deposition, we can see from the 161 whether there is some there are some issues there or not.
Yes,
Then
your
we
lord.
can come to some kind of a some kind of an opinion.
Yes, your lordship.
Whether this is correct or
Yes, yes.
prima
That
facie
is
can be taken.
that is there.
That we can.
Yes, your lord.
The only thing is that arms act.
Arms act is there, your lordship.
So, possessing arms.
And arms, it is. This is not a case where arms were not seized, my lord. If it was not seized, then they definitely would have a good case, my lord. Then the court could come to a finding that arms was never been seized, although there is an allegation, my lord. But here is a case where arms is seized. And my lord, to that effect, to my submission, your lordship, I will have to rely one or two judgment, your lordship, on 480 to 528, where it can be exercised, my lord. Because your lordship, in this case, FIR clearly disclosed commission of offense. And your lordship, on record, nothing is there, no allegation of your lordship threatening to the witness is there. But your lordship, in this kind of cases.
Yeah, you assist me in one thing. I mean,
Yes.
if FIR is disclosing some offense.
Yes, my lord.
Now later on, there is a statement comes from the mouth of the complainant.
Yes, my lord. Yes, my lord.
Stating that in fact nothing has happened.
Yes, yes, my lord.
In that situation, though FIR discloses something, because part of the moment the FIR was filed, but later on, I mean, backtracks it. In that situation, what court should do?
Yes, your lordship, I've already submit on that aspect, your lordship. Your lordship, even on that one of the case, your lordship, that case, I made a submission that later on, if he turned hostile, whether because of that hostility, whether that will affect the veracity of the FIR or not, my lord. According to my humble understanding, no, my lord. Because, your lordship, the judgment which was rendered by the Honorable FX Court, it says if FIR disclose commission of an offense, the court should not interfere. Should not in Nyarika case, my lord, Nyarika infrastructure case, that court the investigation should be proceeded because otherwise it will be hazy fact, and court cannot act on the hazy fact circumstances. So after that, if investigation is completed, then two results may come up. One is the final report, nothing found against the accused, and second is the charge sheet. If charge sheet come again, your lordship, the FIR survive, even the charge sheet survive from 482. Now, your lordship, during the trial, is the domain of the trial is the court, magistrate court, my lord. Now, magistrate, when trial commences, my lord, the ultimately trial will be concluded into either acquittal or the conviction, honorable acquittal or acquittal, my lord, for benefit of doubt. All these things will come up. Now, the thing is that only because that person has turned hostile, then they will rush to this honorable High Court, your lordship, by invoking 482 power. So that will, my lord, that will in fact affect the very principle laid down by the honorable FX Court that the if FIR disclosed cognizable offense, then if he done hostile, because there are many circumstances may come up, your lordship. That is why, your lordship, even the witness protection scheme has been introduced, my lord. Even the Supreme Court has given endorsement to that. So now, in this case, your lordship, I cannot make submission on that because there is nothing on the record. But, your lordship, the court cannot shut its eye, my lord. Because the materials so collected during the course of investigation, the court can keep a prima facie view, my lord. That during the trial or during the investigation, whether the accused was granted bail or not, whether he was on bail or not, and, your lordship, the settlement which they are coming with the settlement. Your lordship, interestingly, your lordship will find one thing. In his deposition, the deceased person says Lokam Talo was unknown to him. How why all of a sudden known to the Lokam Talo? And taking a stand after so many years. Incident was of 2016.
No, in fact, in the cross-examination, he later on says that he
knows Lokam.
He knows Lokam.
Yes, and my lord, the time of your lordship settlement, after pendency of this case, when they realize, your lordship, that there is a difficulty to come across this.
That always happens like that.
Yes, your lordship. Then they come with a settlement, your lordship. And that too, she is not the party to this case. No doubt, your lordship, the CRPC says the family member, legal heir, guardian, they all are come under definition of victim. That is there. But they have never implemented it. I'm not raising this issue. I have not raised that issue earlier also because
The husband is deceased, so says.
yes, but she, your lordship, perhaps she was not implemented, my lord. That implement must be there, my lord. Only the state is party, my lord. She was not implemented. Now,
My lord, for clarification, my lord.
Yes.
While filing this application, my lord, by that time already the complainant has died, my lord.
No, he in the learned PP is submitting that she could have been implemented later on also. Is it your submission?
yes, my lord. If your lordship, she is come with an affidavit, my lord. Representing whom, my lord? She is not the party in this case. And whether her affidavit can be taken into consideration when she has not been implemented, my lord. That is second aspect, my lord. All of a sudden, case is pending. We don't know how they have settled the matter, but they have settled the matter or not. And affidavit they have filed or not. Later on, many things may come up. We don't know, but we have to live in present. That consequences we deal with on the later part. But now, your lordship, she come with an affidavit. Despite the fact that she is not the party in this case, it is only the prosecution as my lord. And we prosecute your lordship, the accused. And victim cannot be made driver of the prosecution, your lordship. Now the case was pending. They have settled the matter and not with the accused. And she is giving a statement that my husband told me that he was forced to do this and that. The veracity of all this aspect cannot be considered at this stage by this honorable court because, your lordship, the allegation, the matter which are dealing by this honorable court is the case which is pending before the trial court, wherein, your lordship, FIR clearly disclosed commission of cognizable offense. And after investigation, through investigation, material comes up and it in fact support the offense under which it was initially registered. But because of some, your lordship, the statutory bar that is for sanction, for arms act, and for the other offenses, my lord, sanction is not required, so it was proceeded.
No, I got it. Now, do you have any kind of precedent?
Yes, my lord.
Precedent about on the issue of, while pendency of the matter in some cognizable offences.
Yes, my lord.
Non-cognizable offenses. Non-cognizable offenses, when this 480 petition is pending, then the private parties come to a settlement, and what will be the status of the settlement?
My lord, on that aspect, I have searched.
There should be so many cases.
Yes, but my lord, I have never come across the judgment wherein it says that FIR disclosed cognizable offense, and later on the charge sheet is filed, and trial they turn hostile, or even there is nothing come up during the trial, then it will have a reverse effect on the FIR. I have never come across this kind of judgment, my lord.
That I understood, that I understood.
But in settlement, if it was there was a
I
settlement,
appreciate your argument on
Yes.
that, but now issue is like whether there is a settlement and there are sections which are non-cognizable offenses. In that situation, whether court can.
your lordship, on
I-
settlement, my lord, on settlement, your lordship, my lord can do it because for settlement, your lordship, the stage cannot be taken. Stage is there definitely, but considering the fact and circumstances of the case, the court can always exercise its power for ends of justice because for the harmonious relation of the party also, all that aspect can be taken into consideration. For that, there is no any bar for the your lordship, the stage of the trial also, my lord, because if this court is not inclined, if suppose they come into a set,
In which kind of offenses? In all way.
if it is not against the society, my lord, not against the society, or it's not a mental depravity, your lordship. The Lakshmi Narayan case is deal with Gyan Singh, Lakshmi Narayan, Narendra Singh, your lordship. This whole case deal with the settlement matter, my lord. But so far as this case is concerned, initially now they come with the settlement, but they too, your lordship, the wife is not the party in this case.
Though it's an extortion, it's a very small amount of money.
Yes, that your lordship, extortion part I am not on it. I'm on arms act, my lord, because of the want of sanction.
He's not on the, I mean, the charge is not framed against him.
But your lordship, if your lordship quash this matter, your lordship, hypothetically, if quash this matter, then it will be direct effect on the arms act section also, my lord. And
Yeah, but your people haven't taken that sanction.
but your lordship, the arms has been seized, my lord. And if it is quashed, your lordship, what about that, your lordship, the arm which has been seized or is
But this court has passed this order.
yes, your lordship, in that order also, your lordship, I have made the objection, my lord.
But still, this is a coordinate bench.
Yes, my lord. But your lordship may have the different view also, my lord. If your lordship is
It's a different matter, but like, I mean, the judicial decorum doesn't.
Yeah, that is there.
Doesn't allow
Yes,
that.
yes, your lordship. But the fact can be distinguished, your lordship.
You also argued this case?
Yes, your lordship. My objection is there, my lord. There are 5, my lord.
But you have argued in that case that there was no settlement agreement.
Yes, there was also, my lord.
They have filed it joint.
No, your lordship. Later on, your lordship, they have made the party, but later on, your lordship, the record has to be looked into because I didn't find any settlement there in that case
But
also.
they have jointly paid for that.
Joint.
See, the initial thing only,
Yes, your lordship. They have
joint
jointly.
application file under 528.
Yes, they have
Is it?
joint application file, but settlement deed was not there, my lord.
A joint application means that there is some settlement with them.
Yes, my lord, that is there, your lordship. But that my submission is on that aspect that here they come with a settlement agreement, your lordship, a non-judicial paper with some consideration. And what consideration is there?
Whether this arms act thing was discussed here? No, it was not discussed.
Not discussed. Only 511, your lord.
You have not you have not pointed it out to this court.
Your lordship, I have pointed out everything in that case also, your lordship. Perhaps in that case, your lordship, no recording regarding the registration of FIR case. Your lordship will find in para 2, it says proceeding against Pitna in connection with GR case number 134 Itna 511 IPC, man.
No, I think in that case, this arms thing was not involved.
In arms was not there, my lord, because
Arms
if,
was not there.
yes, if GR case is there, then definitely if arms act was there, it ought to have been mentioned, my lord. Arms was not there. In this case, what has happened, my lord? They've jointly filed, but there was no settlement deed. And
No, this is a straightforward case.
Yes,
where
and-
both of them filed jointly.
yes, and
And there
they,
was no arms involvement of arms act.
yes, your lord.
So from this judgment,
Yes.
at least there is nothing come out from it.
Yes, yes. And they are relying on the statement of the prosecution witnesses.
So it was a straightforward case.
Yes,
It-
yes.
It could have been done.
Yes, yes,
So that's why rightly done by this
yes, yes,
honorable court,
Yes, Your
ordained bench of this honorable
Yes.
court. But here the case is a little bit different.
yes, little bit different, my lord.
Is it different?
Yes, yes, your lord.
Sure.
Yes, your lordship, from the record, your lordship, it can be, inference can be drawn that there was no arms act and they have settled the matter, your lordship.
Okay, what are the case laws we have?
Case law, my lord, I have two case laws, my lord. One is Supriya Jain, reported in 2023 SCC online SC.
You have copies?
Yes,
for
my
me?
lord.
Just give it to me. Do you have any case laws to rely on?
No, my I have, this case law will deal with
Yeah, Supriya Jain matter, yeah, paragraph.
paragraph, my lord, 17, my lord. Certain parameters has been reiterated by the apex court in this kind of cases.
You show me the FIR part. If FIR discloses
Yes, my lord, 17,
the offense.
yes, from 17, my lord, this in fact will cover everything, my lord. May I read if your lordship allow?
Yes, please.
17, my lord, yeah. This is a case where the charge has been framed and the accused are awaiting trial. Having regard to the totality of the fact and circumstances noticed above, we are of the considered opinion that the investigation and the follow-up steps are not so patently and unobstructively defective or erroneous, except to the extent we propose to mention before concluding our judgment, that allowing the trial to progress might cause a miscarriage of justice. This is also not an appropriate stage to delve deep into the record. It is no part of the business of any of the courts to ascertain what the outcome of the trial could be, conviction or acquittal of the accused. The small window that the law through judicial precedent provides is to look at the allegation in the FIR and the material collected in the course of investigation without a rebuttal thereof by the accused, and to form an opinion upon consideration thereof that an offense is indeed not disclosed from it, your lord. Unless the prosecution is shown to be illegitimate so as to result in abuse of process of law, it would not be proper to curtail it. The principle to be borne in mind with regard to the quashing of a charge sheet proceeding either in the exercise of jurisdiction under section 397 CRPC or 482 CRPC or together, as case may be, has engaged the attention of this court many a time. Reference to each and every precedent is not unnecessary. However, we may profitably refer to only one decision of this court, where upon a survey of almost all precedent on the point, the principle has been summarized by this court scantly. In Amit Kapoor versus Ramesh Chandra, this court laid down the following guiding principles. 27.1, first point, my lord. Though there are no limit of the power of the court under section 482 of the court, but the more power, the more due care and caution is to be exercised in invoking this power. The power of quashing criminal proceedings, particularly the charge frame in the term of section 228 of the court, should be exercised sparingly and with circumspection, and that too in rarest of rare case. The court should apply the test as to whether the uncontroverted allegation as made from the record of the case and the documents submitted therewith prima facie establish the offense or not. If the allegations are so patently observed and inherently improbable that no prudent person can ever reach such a conclusion, and where the basic ingredients of a criminal offense are not satisfied, then the court may interfere. The High Court should not unduly interfere. No meticulous examination of evidence is needed for considering whether the case would end in conviction or not at the stage of framing of charge or quashing of charge. Whether the exercise of such power is absolutely essential to prevent patent miscarriage of justice and for correcting some grave error that might be committed by the subordinate court, even in such case, the High Court should be allowed to interfere at the threshold to throttle the prosecution in exercise of its inherent power. 5. Where there is an express legal bar enacted in any of the provision of the code or any specific law in force to the very initiation or institution and continuation of such criminal proceeding, such a bar is intended to provide specific protection to the accused. 6. The court has a duty to balance the freedom of a person and the right of the complainant or prosecution to investigate and prosecute the offender. 7. The process of the court cannot be permitted to be used for an oblique or ultimate or ulterior purpose. 8. Where the allegation made and as they appear from the record and document annexed therein to predominantly give rise and constitute a civil wrong with no element of criminality and does not satisfy the basic ingredient of criminal offense, the court may be justified in quashing the charge. Even in such case, the court would not embark into the critical analysis of the evidence. 9. Another very significant caution that the court have to observe is that it cannot examine the fact, evidence, and materials on record to determine whether there is a sufficient material on the basis of which the court case would end in conviction. The court is concerned primarily with the allegation taken as a whole, whether they will constitute an offense, and if so, is it the abuse of process of the court leading to injustice. It is neither necessary nor is the court called upon to hold a full-fledged inquiry or to appreciate evidence collected by the investigation agency to find out whether it is a case of acquittal or conviction. 11. Where allegation give rise to a civil claim and also amount to an offense merely because a civil claim is maintainable does not mean the criminal complaint cannot be maintained. In exercise of its jurisdiction under Section 228 and or under Section 482, the court cannot take into consideration the external material given by the accused for reaching the conclusion that no offense was disclosed or that there was possibility of his acquittal. The court has to consider the record and the document annexed therewith by prosecution. Quashing of a charge is an exception to the rule of continuous prosecution, where the offense is even broadly satisfied.
For a second, let's pause for a second. 27.1.2.
27.12, yes, Your Lordship.
In excess of his jurisdiction under section
The
228.
court cannot take into consideration external material, my lord.
So whether it can be considered external material? This
Yes, my
settlement?
yes, my lord. Your Lordship, even the exception to that, there is a judgment, one more judgment, Your Lordship. If that material is of sterling quality, and if it is taken into consideration, that will lead to the charge of the accused, my lord, in the allegation against the accused, then that will be the exceptional circumstances where court can take the external material of the accused person. But this, Your Lordship, this
Here also in this case, only statement is that he has not committed the offense.
offense, that much only.
Correct.
Yes, my lord. And that too come from the victim side. But however, Your Lordship, it is not a part of the record of the investigation agency when it was investigated. Because, Your Lordship, from the preceding, Your Lordship, the paragraph, Your Lordship has found that it is on the allegation, my lord, whether the allegation disclose the commission of cognizable offense or not. If it is disclosed, then court should not, Your Lordship, curtail the further proceeding of the case, my lord. Here, till charge sheet, Your Lordship. Now, Your Lordship has, if Your Lordship is inclined, then Your Lordship has to quash the proceeding before the court, charge sheet also, and the FIR also. But for quashing the charge sheet and FIR, there must be a justification that this FIR or allegations are false or not justified, and this cannot be prosecution failed to, Your Lordship, this case has been, is a vexatious case or false allegation has been made against the accused. But there is nothing to show from the record that there is, the allegations was false or motivated one from the third person, my lord. It is only the statement of the informant wherein he has stated before the court that in a blank paper he was forced to put a signature. That much, my lord. And he was declared hostile. That is one of the facts, Your Lordship. He was declared hostile, my lord. But no doubt, Your Lordship, cross-examination, with due respect to my brother who has done the cross-examination, the vital fact has not been bring into record by exercising 145 of the Evidence Act, my lord. You ought to have, Your Lordship, the 161 statement record before the police, Your Lordship. All these things has to be done, which are, Your
Yeah,
Lordship,
it was not done.
not done properly, my lord.
But what, 27.2, what is your submission on this, that this, can it be termed as external material
My lord,
settlement?
the settlement is in, yes, Your Lordship. That was why, because, Your Lordship, here, prior to that, my lord, the 27.10 has to be looked into again. It says, it is neither necessary nor is the court called upon to hold a full-fledged inquiry or to appreciate evidence collected by the investigation agency to find out whether it's a case of acquittal conviction.
But this is clear. This is clear.
And Your Lordship, yes, 27.12 itself is clear. In exercise of its jurisdiction under Section 228 and or Section 482, the court cannot take into consideration external material given by the accused for reaching the conclusion that no offense was disclosed. Here again, Your Lordship, it says no offense was disclosed, but it clearly disclosed, man. Offense was disclosed. The material should be of that extent, of that impeccable quality or sterling quality. If consider, then your lordship, the allegation, it will directly hit the core of the prosecution case. Yes, it was a false allegation, man. But now again, one thing comes, my lord.
Here also it's saying that nothing has been done, no offense is committed.
But your lordship, that statement, that what I'm your lordship tried to submit earlier, she was not made party in this case, first of all, my lord. And that statement, which they come within a settlement did, my lord.
Now, since they have filed an affidavit on oaths,
Yes, your lord.
and they have placed this this material or document or whatever affidavit on record,
Yes, your lord.
then I cannot just, the court cannot just
Ignore the material. Yes,
ignore these documents.
Yes, yes.
Correct?
yes, your
So
lord.
now only thing is that like whether 2712 will be of your help or his help.
2712, your lordship, it's for my help, my lord. Why I'm saying to your lordship? Because that material, whatever is there, it should be directly connected with the offense, your lordship, alleged offense, my lord. This is the material whichever they bring into the record. That material was created by them. It was not present during the time of investigation. If this material was there at the time of investigation, then he was never been charged sheeted, perhaps, my lord. But it has been brought on later stage, your lordship. And now the law says, your lordship, that if FIR disclosed allegation, in this case, your lordship, if this matter is on settlement, my lord, my submission would have been different, my lord. But this is not on settlement, my lord. This is not a joint petition, my lord. They have challenged on merit on the ground that before the trial court, the informant has done hostile. And there is no material to substantiate the prosecution case before the trial court.
So your submission as affidavit is not a settlement, not a settlement.
It cannot be,
Yeah.
since your lordship,
In a true sense.
yes, your lordship, it cannot be, your lordship, because she is not even a party in this case, my lord.
But he's also one of the victims.
But your lordship, she was not been impleaded, my lord.
Yes, any other point that this I mean, we are reading to 27.13.
Yes, your lordship. The quashing of charges is an exceptional to the rule of the continuous prosecution, where the offense is evenly broadly satisfied. The court should be more inclined to permit continuation of prosecution rather than its quashing at the initial stage. The court is not expected to marshal the record with a view to decide admissibility and reliability of the document or record, but is opined from prima facie. 27.14, where the charge sheet report under section 173(2) of the code suffer from fundamental legal defect, the court may be well within its jurisdiction to frame a charge. 27.15, coupled with any or all of the above, where the court find that it would amount to abuse of process of the court or that the interest of justice favor, therefore, otherwise, it may quash the charge. The power is to be exercised ex divetio, that is to do real and substantial justice for administration of which alone the court exists. There are the principles which individually and preferably cumulatively one or more be taken into consideration as percepts to exercise of extraordinary and wide plenitude and jurisdiction under 482 of the court by the High Court. Where the factual foundation of the offense has been laid down, the court should be reluctant and should not hasten to quash the proceeding, even on the premises that one or more ingredient has not been stated or do not appear to be satisfied if there is substantial compliance with the requirement of the offense. Very much, my lord.
The other case,
Yes, well, Lordship, one more case is there, your Lordship. This Aryan Singh, your Lordship. 2023 SCC online, SC 379, my lord. 23
yes,
SCC online, SC 379, my lord.
Sarah,
Para 10 and 11, my lord. Para 10, may I read, my lord? From the impugned common judgment and order passed by the High Court, it appears that the High Court has dealt with the proceeding before it as if the High Court was conducting a mini trial and or the High Court was considering the applications against the judgment and order passed by the trial court on conclusion of the trial. As per the cardinal principle of law, at the stage of discharge and or quashing of the criminal proceeding, while exercising the power under 482 of CRPC, the court is not required to conduct a mini trial. The High Court in the common judgment, impugned judgment and order has observed that the charge against the accused are not proved. This is not the stage where the prosecution investigation agency are required to be proved the charge. The charge are required to be proved during the trial on the basis of evidence laid by the prosecution investigating agency. Therefore, the High Court has materially erred in going into the detail in the allegation and the material collected during the course of investigation against the accused. At this stage, the discharge or while exercising power under 482 CRPC, the court has a very limited jurisdiction and is required to consider whether any sufficient material is available to proceed further against the accused for which the accused is required to be tried or not. One another reason pointed by the High Court is that the initiation of criminal proceedings is malicious. At this stage, it is required to be noted that the investigation has been handed over to the CBI pursuant to the direction issued by the High Court. That thereafter, on conclusion of the investigation, the accused person have been charge sheeted. Therefore, the High Court has erred in observing at this stage that the initiation of criminal proceeding is malicious. Whether the criminal proceeding were malicious or not is required to be considered, not to be required to be considered at this stage. The same is required to be considered at the conclusion of trial. In any case, at this stage, what is required to be considered is prima facie case and the material collected during the course of investigation which warrant the accused to be tried. So that part is already gone, my lord. The material was collected, and now the trial has been proceeded. Now only basing on the statement before the trial court, your lordship, they are approaching the court. So my humble submission would be, your lordship, if prosecution fail to establish their case before the trial court, then either he will be acquitted or if the prosecution succeed, he will be convicted. This is a acquittal or conviction stage now, your lordship. 482 exceptional, they have to establish exceptional circumstances. But for that, your lordship, the FIR and
that stage is that now this deposition has been recorded. I mean, this, PWs.
Is going on, madam.
At what stage?
PW stage, madam.
PW stage.
Yes, my lord. Yes, out of my lord.
313 stage hasn't come.
No, my lord.
313 hasn't come.
No, my lord. It's at the stage of PW, madam.
And how many PWs are there?
My lord, there are, my lord, 8 PWs, my lord.
So how many?
Out of that, my lord, 4 PWs has already been examined, my lord.
that much, your lordship. Or your lordship may direct to expedite the trial if there is a delay, your lordship. That's it.
My lord,
Apply.
Yes.
my lord, may kindly see, my lord.
You have submitted only. You want to reply to him?
Yes, my lord. Only one thing, my lord. Since, my lord,
Yes, please.
my only, my lord, this contention is that, my lord, no offense as alleged was ever committed by the petitioner, my lord. It was only for the reason that we had a political rivalry, my lord, in view of the election, my lord. So therefore, they have engaged this person and obtained the signature of the complainant, my lord. That, my lord, in such circumstances, my lord, it was the same case in the, my lord. We have just, my lord, placed the judgment. Order of this honorable court, my lord.
But what about the arms?
So, my lord, that is, I have just clarify, my lord. My lord, may I kindly see that the charge sheet was filed on 6/3/2008, my lord.
1 second. Charge sheet is at page.
Page number, my lord. Page number 17 to 98, my lord. 70. My lord, page number.
No, page not. It's not 72.
17, my lord.
17.
Yes, my lord. 17, my lord. No,
Yeah, page 21.
page 21 here.
Type copy, page 21.
My lord,
Yes,
no,
charge
no,
sheet
my
was,
lord.
yeah, you are
Yes.
talking about the date.
Date,
Charge
my
sheet
lord,
was
yes, sir.
filed on.
For that, my lord, we need to see page number 17, my lord. It was filed on 6/3/2008, my lord.
Page 17. 6,
6/3/2008, my lord.
yes, 6/3/2008. Yes,
Yes, my lord.
yes.
While filing the charges, my lord, they have sought for this,
Sorry.
the prosecution, the state has sought for sanction, my lord, for this, against this arms act, my lord. Since 2008, my lord, they are seeking for this sanction. Till date, my lord, the court has this framed the charge on, my lord, 2/6/2022, my lord.
Charge framed on.
On 2/6/2022.
Okay, yeah,
No.
that sanction is yet to be arrived.
Yet to be arrived, my lord. They have applied in the year 2000, my lord, 8, my lord. Since then, my lord, it is from 2008 to we are in.
When
this,
was the seizure made? Is there any, when is the seizure made? The seizure list is there, no? You said?
Yes, my lord. Page number 44, my lord.
Column 10 is also there for the seizure list.
Page number 44, my lord.
Forty-four, yes, Your Lordship. Country made pistol, 9 mm. Inscribed as a made in India or something. China is made recent.
It was done on 27/2006.
Yes.
So one Maruti car and other arms enemy. Maruti car was on 19/7/2006 and 27 these arms. The seizure was country-made pistol 9 mm, made in India, China, Smith Vision. Smith Vision, what is this? KB Loydo, or something like that. KB Loydo YCIA. Country-made Russia arms. So 3 pistols over 3 arms.
No, my lord, only one, my lord.
Why country-made pistol? Then China Smith Vision. Wait, what is this?
No,
Then country-made pistol made in Russia. Three arms. 3 arms and 13 rounds of ammunition.
Oh.
Page 44. You come to
yes,
page 44. See, first one is country-made pistol.
as for this, my lord, we can see that yes, 3 arms were seized, my lord.
It's on record.
But my lord, the one fact, my lord, I have not, my lord, submitted, my lord. IO, my lord, of the case has also been examined
Yeah, where is the eyes?
by the court, my lord. We have my lord, after filing of this
No, IO statement.
application only, my lord, the this statement
IO
of
hasn't been examined.
IO has been examined, my lord.
So where is that?
After
The
filing,
filing of this application.
yes, my lord. Now,
You don't have also.
It must be there in the TCR, madam.
on 20/12/2024, my lord.
On 20.
2024. Neither the IO has sought for this further time for this obtaining sanction, my lord, nor he has produced any arms, my lord, before the court. If at all any arms were seized, my lord, I would have produced before the court, my lord. My lord, may I kindly see the date, my lord.
My lord, may allow me to find it out, my lord.
Okay. Pencils.
My lord,
It is
it
not
is not
there.
the updated this year. It contain till 26/9/24. And according to them, it was recorded in the December 24.
That is what I want to say.
Yes, ma'am. The Purana.
You don't have a copy of that? What is the instruction on this?
My instruction, my lord, is that, my lord, since IO has been examined, my lord, and he is neither sought for any time for this obtaining sanction from the authority, my lord, nor he has produced anything, my lord, any material against the accused, my lord. Since we have seen in the, my lord, charge sheet, that as many as 3 weapons were seized, my lord. But I was failed to.
Without that record, I mean, how do I?
My lord, can this matter be taken up to the witness them, my lord, so that we can obtain this?
We have finished only the hearing. We have already finished.
Yes.
It's all over.
Only to produce that, my lord, the statement of the IO, my lord, in the trial court. We'll just submit, my lord.
You can bring it.
Yes, my lord.
Or it will take some time, no? If I direct it to police it.
Yes. Your lordship, it is in the UPI itself, your lordship.
It's here.
Yes, here only.
So how much time you can take?
Your lordship, it will come to registry, my lord. It's a TCI, it's a trial court, your lordship. We do not have the control over it.
So how much time usually it takes?
Your lordship, will your lordship, in fact, if your lordship direct, then we'll directly make a contact to the concerned sister, your lordship, the official, to send it as early as possible, man. Maybe on your lordship, Thursday, my lord. Yes, today is Monday. 2 days at least. Within 2 days, your lordship, it will just send a statement only.
Just a statement. I just wanted to have a look.
Yes.
What was. So we'll do one thing. We'll conclude the hearing.
Yes, your lordship. Yes, your lordship.
I'll keep it for judgment.
Yes, your lordship.
Only thing is that on Thursday, that both of you
Yes.
can be there,
Yes.
and I'll just have a look on that.
Yes, yes,
Correct?
yes, your lordship.
Heard Mr. So and so learned counsel. Your name, please?
D. Kamduk, my lord.
D. Kamduk.
Yes, ma'am.
Heard Mr. D. Kamduk, learned counsel, appearing for the petitioner. Also heard Mr. Ete, learned PP,
Additional PP.
learned APP, appearing on behalf of the respondent. the matter is heard at length. And hearing concluded. At the late stage of the hearing, it has been submitted by the learned counsel for the petitioner that statement before the trial court of the IO in the instant case has already been recorded, and he submits that statement of IO will be very relevant for proper adjudication of the instant case. And therefore, he prays that the statement of the IO may be directed to be produced before this court. After considering the matter and materials and record, this court is of the opinion that the statement of the IO shall be relevant in the instant case. Accordingly, the registry is statement of record of the IO in the instant case shall be produced before this court on or before on or before 20th August
Yes, my lord.
2025
From CGM court, my lord.
from the court of CJM
UPI. UPI GR case number.
in the write it down in the from the court of CJM UPA in the GR case number
133
133
6
6 133
133 of 2006, my lord.
2006. Registry is accordingly correct. Huh? This is correct.
Yes, yes, my lord. 133.
Registry is accordingly directed to take appropriate steps expeditiously so that the aforesaid document can be placed before this court on Thursday next, that will be 21st. 21st, when on the matter will be listed again for further hearing.
Yes, sir.
The conclusion part you can cut. Matter remain part heard. You keep. Matter remain part heard. The conclusion part you can cut. You cut that. The matter remain part heard. Release this matter on accordingly on 21st August for further hearing.
Much obliged.
So I'm keeping this.
Yes, yes, madam. Oblige.
Item number 2.
Your Lordship,
Yes.
I'm appearing for the appellant on behalf of learned counsel Mr. G. Kato. Gedo Kato. Your Lordship, TCR may be required in this case. Trial court record from the District Court UPA.
Why TCR is required in this case?
Your Honor, to ascertain the dates since the order, the
You have
implement.
filed an FAO,
Yes, Your
and
Lordship.
you have filed
And
IA
IA,
also there. Or
yes,
no,
for stay.
here only, huh?
Yes. For stay.
There is
and-
nothing in the matter. We can decide this matter without TCR.
Your Lordship, since the order, the impugn order states that
It has been reflected as, it is observed from the,
Where, which page?
second page of the order, impugn order. It has been observed as such. Your Honor.
Second page of the impugn order.
Yes, Your Honor.
It
Paragraph,
is at which page? Impugn order is at which page?
impugn order is at, Your Lordship, at the first, it should be at the first,
It should be
page,
first only.
before the index, after the index, I mean,
Yes, got it.
in the next page, Your Lordship.
Hmm.
In the middle part, it is observed from the record of the case, the petitioner has not taken any steps as provided under so and so. However, the petitioner has filed an application under Order 39, Rule 2A CPC, but the same is withdrawn by the council. Later on, the opposite council has entered appearance before this court and filed an application for vacation of the order of an interim injunction, which is registered as IA so and so. Your Lordship, how the learned district judge has observed this as, we had firstly, it is reflected as we have not taken any steps. However, the petitioner has filed an application under Order 39. However, in between these two, instances, there has been many gaps. Only to ascertain, because the council, they have appeared on 6th on June.
I'm not getting the paragraph. Page 2, which paragraph you are reading?
Page,
Yes, I got it now.
it is observed from the record of the case. It is,
Now, what is your submission on this?
my submission on this is that the learned district judge has observed our case as though we have, after filing of the injunction application, immediately we have filed this,
Withdraw.
yes, withdrawal application. No, not exactly withdrawal, this Order 39, Rule 2A, where it is for disobeying of this injunction order, disobedience.
Order, yes,
Order 39, Rule 2A.
the same has been withdrawn by land company.
Yes. Here it is observed, the learned district court has portrayed the case as that after getting the interim injunction, we have again filed then this order, this application under Order 39.
Yes.
Yes, but the case was,
that you have withdrawn.
yes, we have withdrawn that, but the case, however, was not that, Your Lordship.
What was the case?
We got the interim injunction on April. However, we could not take the steps, and the same was after taking the fresh steps. The same was delivered on May. That they have received the,
No, that is fine, but after that, that vacation of injunction was filed, right?
yes, Your Lordship.
The vacation of injunction was filed.
Yes,
It was heard at length.
yes, Your Lordship.
After hearing that your injunction was vacated,
Yes, Lordship.
then that vacation order you are challenging here now in the High Court.
Yes, Lordship.
So what is there? Because see, I mean, you have filed a petition,
Yes,
application for injunction.
yes, Lordship.
Correct. The injunction was initially granted.
Yes, Lordship.
Then they have filed an application for vacation of the injunction. That matter was heard at length.
Yes,
That in between whatever happened,
yes,
that is immaterial now.
Hmm.
Then that was vacated. Then
Yes,
you have come before this court challenging that, and your interim order was considered at length.
yes, Lordship.
Interim prayer was considered at length.
Yes, Lord.
After considering your interim prayer, the matter was your interim prayer was rejected.
Yes, Lord.
Now matter is for admission hearing. So you argue the matter. There's nothing. I mean, is there any need for TCR? I don't think there is any need for TCR.
Just to ascertain this issue, I was instructed to, just for this issue, Your
That
Lordship.
issue is gone now.
Yes.
That issue is gone. Because you were during the argument on vacation of the injunction,
Yes,
you could have placed all those things.
yes, Your Lord.
You must have placed all those things. And after hearing that the matter was rejected. Injunction was vacated.
Vacated.
And against that order, you have come to the High Court,
Yes, Your
filing an
Lordship.
FAO, isn't it?
Yes,
Now your FAO in the interim prayer that has been rejected by
Yes.
this court.
yes,
Now only thing remains is that like admission hearing of this FAO
yes, Your Lordship.
that you can argue. Is there anybody else is hearing?
Yes, my senior,
Your senior who?
Gedo Kato, name is reflected in the cause list.
What's his name?
Gedo Kato.
Kato. G Kato.
Yes,
So he's not there in the court today,
no, Your Lordship.
but he was there in the division bench.
No,
He's different Kato.
Marto Kato, sir. That's,
There are two Kato.
there are two Katos.
Okay, okay. So when he'll be available next week?
2 weeks.
2 weeks, Your Lordship.
Hmm?
2 weeks,
Not 2 weeks. After 1 week.
1 week.
After 1 week. This is a small matter.
Yes, Your Lordship.
You are Mr.
M. Tangzang.
Please write learned counsel for the petitioner appears and submits that his senior, Mr. G Kato, is not available today in the court. Accordingly, he prays for accommodation for a week. His prayer is not objected by
No, VT Guru.
Mr. So-and-so learned counsel. You are appearing for?
For the respondent Jitalo. Jitalo.
You are appearing for who?
The respondent party.
Your seniors there?
Jitalo.
G Kato.
Talo.
Hello. Okay. Then you are appearing for the respondent. Huh? Also, how many respondents are there?
1 Your Lord.
Mr. So-and-so appearing on behalf of Mr. So-and-so, learned counsel for the sole respondent, doesn't have any objection to the prayer made by the petitioner's counsel. Let this matter be listed on next week one book. Give me a book. On 26th.
26.
On 26th, let this matter be listed again on 26th August for admission hearing.
Item number 4.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, this is a regular bail, Your Lordship.
1 second. Up-to-date case record was submitted.
Yes, TCR, my lord. Perhaps it has been received, my lord. The trial is pending, my lord.
Is this up to date? Because there is a office note on 14/8 that it was not received.
On 24th of July, my lord, the prosecution witness victim statement was recorded.
No. I'm talking of the record.
Yes, my lord.
Learned counsel for the applicant, Mr. Gamesh, Mr. Gamesh submits that there has been subsequent development in the case. On 12/8/2025, this was the order passed.
Yes. Yes, on 25/6.
No, 12/8/2025, order was passed for the records.
Okay.
And 14/8, official note says that updated case records not yet received.
Okay, yeah, that means updated, not yet received. Your Lord.
Yes.
So I'm saying that updated PSR may be there.
So this is an old record.
Yes,
It
Your Lord.
was not updated.
Yes, yes.
That
Reminder.
was this honorable court
Yes, Your Lord.
has passed that order.
Yes, Your Lord. Reminder to the learned session court, my lord, special court, to send the updated one.
Please write. You are Mr.
ठीक है मैं
Mr. T. Gamesh appears, learned counsel appears for the applicant. Mr. Ete, learned APP appears on behalf of the state. As per the office note dated 14/8/2025,
My lord, she is appearing for victim.
oh,
Is it-
Miss
Also
MS A. Dorji,
J. Doji.
J. Dorji appears for the respondent number 2. seen the office note dated 14/8/2025, it is seen that up-to-date case records of this incident case is yet to be received from the Districts and Sessions Court UPR. In view of the above, call for the updated records of the case. We'll list it on next week.
Yes, your lordship.
Let the matter be fixed on 26.
26.
Yes, your lord. 26.
Is there any subsequent development in the case?
Yes.
What happened?
Your Lordship, earlier when I filed this very petition,
Hmm.
there was no report of the statement of complainant and victim.
Hmm.
Despite of notice being served to the complainant and victim. And now on 24th July 2025, they have been appeared before the court and they submit their statement in the court.
Did you file a bail application earlier?
Yes. This is the pending bail application
No, this is a pending one. No, before this, no.
for the session court.
Before the session court, you filed. That was rejected.
That was
Okay, we'll fix it on next Thursday. By the time record will come.
Yes, perhaps.
what happened?
Oblige.
Item number 5. May I please, my lord?
Here also like this updated scan copies are not received.
There was a direction by this honorable court to
The authenticity of the patient booklet,
my lord.
has it come?
Yes, my lord.
Right.
Is there in the case diary, your lordship? It's regarding the your lordship status whether he is suffering from HIV or he was HIV positive or not, madam. It's there, my lord. Impression diagnosis on admission. HIV positive.
So he's suffering from HIV.
Your lordship, the record it says, your lordship. Otherwise, the on earlier order rejection of the learned court below subordinate court, your lordship. There, your lordship.
There it was the HIV negative.
Yes, your lordship. Here, your lordship, in the petition, my lord will find in annexure 7, my lord. The remark is there, my lord. Page 32.
You are filing an objection to this.
No, my lord, they have a ground that since he's suffering from the HIV, on that ground he is asking for the bail, my lord, the enlargement.
Yes. It says negative. It was dated 18/6/25. When was the order passed? Please have a look and verify. Order is annexed here. 58, sorry, page number? No, you just let me have first rejection. This was a report on
18.6.
25. When was the first rejection? Prior to this? You don't have the order with you. It's on annex here. Yeah. Page number 17. Yes. Upon hearing the person, it is testified that the accused HIV is negative. No, 1 second. Then let us go to that report. What was there? Where was that? Page 32. So it says negative only. So it was tick marked in HIV, and he took it as negative HIV too. And this one is from Mr. AK. This is from
I have not submitted any judgment.
no. This
Oh, that, yes, Your Lordship, I've received from the concerned, Your Lordship, the investigation officer, my lord. But there, Your Lordship will again find on admission. It's written on admission. My lord will find in the left side on the margin side, Your Lordship, the remark on the second page. Yes, Your Lordship.
second page.
Yes. The top part, Your Lordship, RK mission
Yes.
explanation has been written, and Your Lordship find the HIV is written by hand, and Your Lordship will find in the left side the on admission it says, my lord.
No, I don't get any addition. Second page.
Yes, my
This one.
no, my lord. The page your yes, Your Lordship. I have that one.
Operation diagnosis on admission.
On admission, yes, Your Lordship. There it says it's written HIV positive, but otherwise, also, Your Lordship, that alone cannot be a ground for granting bail. It is recently settled by the held by the FX court while interfering the judgment of the Meghalaya High Court, Your Lordship.
It's a case of what? This is online, right? This is online class. This is the correspondence. Are you going to university where? Arunachal Pradesh. Don Bosco College. Then what was the thing? What was the offense? Where is that? Where is the FIR? So basically, allegation is that he is forging various documents and taking money from people. Direction is how come it's quite peculiar. Page 26, yes. In the public interest, following officials are directed to conduct patrolling. Huh? How come he has become an officer? He was only asked to this thing patrolling, but he has been taking money. Yes, yes. Yes. Sarah? Yes, yes, yes.
Yes, my lord, since your lordship, the bail is a matter of discretion. However, the discretion is not absolute, your lordship. The certain parameter has to be looked into.
Now,
Your
what
lordship
is
may
your-
kindly
what
come
is
to,
your objection to this?
your lordship, on HIV, I will come with a judgment, my lord. But your lordship may kindly see para 4, my lord, of their petition, your lordship. Paragraph 4 of their petition, my lord.
Once,
And and perhaps your lordship, the statement of the deputy commissioner is also on record, my lord. On last occasion, we have given the statement, your lordship.
yes, para, which para?
Para 4, my lord.
Para 4 of their petition.
Their petition, my lord. Now here, there is one of their ground is that he is a student, my lord.
Hmm.
But here again, he has stated he has a MTS, working as an MTS in the DC office, my lord. My lord,
One
para
second, para 4.
page 6, my lord.
Yes.
May I read? That the applicant beg to state that the alleged accused person, who is a staff of the Deputy Commissioner Itanagar, was endorsed by the then Deputy Commissioner Sri so and so to conduct patrolling in the capital region to prevent all kind of illegal art cutting, illegal dumping of debris on ROW, river, drain, and illegal construction. On dated so and so, the accused person was also appointed as in charge patrolling Indira Gandhi Park, Itanagar, for being declared as no smoking zone and alcohol free zone. That again on dated so and so, the Deputy Commissioner appointed the accused person as in charge patrolling to maintain law and order in IG Park, Itanagar. The accused person who is working as MTS in Office of Deputy Commissioner, Itanagar, is duty bound to follow the instruction and order issued by his superior authority. The accused person actively involved in executing the assigned duties. The accused person is not indulged in any illegal activity as alleged against him. Here he says he is MTS, working as an MTS, my lord.
Maybe, but still he can carry on his studies.
But your lordship may kindly see the statement of the Deputy Commissioner, my lord.
Yes, where is that?
It's there in the record, perhaps. On last occasion, we have furnished the copy of the statement, my lord. It was actually the part of case diary, but it was separated, your lordship. The statement of Deputy Commissioner, my lord. All the questioners were there, whether the
Last
appointment.
occasion you have given.
Yes, your lordship. It will be in the separate paper, my lord.
It's not there. Last occasion, so there are some case laws you have submitted.
Yes.
The same case laws or different ones? Same. You have a copy of that?
No, my lord. This is the original copy, my lord. Actually, that was a part.
Now, what do you want to show from here?
Your lordship, the statement. Actually, he has stated that the Deputy Commissioner has authorized him for patrolling everything. The statement of the Deputy Commissioner clarifies everything.
But that document is there that he has submitted.
But that also, that is a part of investigation that has to be looked into, because your lordship, the statement.
He says only that he is not an employee, correct? He is not an employee, but like he volunteered and he has been.
Yes, and their only ground is HIV. So your lordship, on HIV, I will punish one judgment, and then your lordship, rest is up to your lordship. Otherwise, your
You
lordship.
have the judgment now?
Yes, your lordship. Bhavani Singh was passed by the Honorable Apex Court.
He's a young guy. He's a young guy
Young guy
suffering from HIV. 62 days already there.
Young guy doing your lordship the
I know, I understand that, but investigation, how much time you require?
Yes, that is there, Your Lordship. Your Lordship, I will refer to para 19, Your Lordship. The case judgment, the name is the State of Meghalaya versus Langring, Thungla, Silo, and another, my lord. This matter, the judgment was passed on 16/7/2024. Now, para 9, my lord. 9, I will refer 9 and 10 of this judgment, my lord.
There are 9 and 10.
Yes, my lord. The may I read, my lord?
Yes, yes.
The material on record would reveal that earlier Srimati X was enlarged on bail by the High Court as per order dated so and so in connection with so and so involving quantity so and so of heroin, despite the opposition of the public prosecutor taking note of her being HIV positive. It said in order, it stated thus, accordingly on this ground alone, the application for grant of bail is hereby allowed. Now 10. The subject FIR, which FIR number so and so under section so and so of NDPS Act, would reveal that the quantity of the contraband involved is so and so of heroin. The impugn order granting to accused Srimati so and so would reveal this time also the bail was granted on the ground that she is suffering from HIV and conspicuously without averting to the mandate under section 37(1)(b)(2) NDPS Act, even after taking note of the fact that the rigor of section 37 NDPS Act called for consideration in view of the involvement of commercial quantity of the contraband substance. When the accused is involved in the offense under section so and so more than one occasion, and when quantity of contraband so and so much above the commercial quantity, then the consideration of the provision under section 37 NDPS Act has to be taken seriously. Lapse. In case of like nature, granting bail solely on the ground mentioned relying on the decision in Bhavani Singh versus State of Rajasthan would not only go against the spirit of the said decision, but also would give a wrong message to the society that being a patient of such a disease is a license to indulge in such serious offense with impunity. In this contextual situation, it is to be noted that Bhavani Singh case, the offenses involved was not one under NDPS Act. We have no hesitation to say that in above circumstances, it can only be held that the twin conditions so and so are not satisfied. And on the sole reason that the accused is a HIV patient, cannot be a reason to enlarge her on bail. Since the impugn order was passed without adhering to the said provision and in view of the rigor thereunder, the accused Srimati X is not entitled to be released on bail. The impugn order invites interference. Now, para 12, my lord, in such kind of case, Your Lordship, what Supreme Court has further directed, in view of the indisputable fact that Srimati X is HIV positive, she is entitled to the benefit under section 34(2) of the Human Immunodeficiency Virus and Acquired Immunodeficiency Syndrome Prevention and Control Act 2017, which reads as under, in any legal proceeding concerning or relating to HIV positive person, the court shall take up and dispose of the proceeding on priority basis. In view of the said provision, the trial court shall take appropriate step to expedite the trial that on priority basis and to dispose of the case on the earliest possible. Now, Your Lordship, the NDPS Act section 37 rigor is there, but we should not forget one more thing, that it is in addition, the CRPC is the principle for granting bail under CRPC or the VNSSS is the addition to the section 37. So that aspect has to be also looked into. Solely on the ground of HIV, the person is HIV positive, he cannot be enlarged on bail. That much, only to that extent I was referring this judgment, madam.
I'll pass the order in the chamber
Yes, sir.
today only.
And my lord, my humble prayer to Your Lordship, that statement of the DC may be written as a part of the case diary, Your Lordship. It was, we have.
It is there.
Yes, no,
solid.
we don't have the. I have the entire case diary, my lord.
Mhm.
But it is not there. It is one of the.
So you want a copy of this?
Is original copy, yes, Your Lordship.
But like this will, I'll require this.
Yes, Your Lordship. After passing of the order, that may be
Mhm.
returned.
Heard Mr. G. Sering, learned counsel for the petitioner, also heard learned APP Mr. Ete. Bail hearing concluded. Order will be passed accordingly. Order will be passed tomorrow.
Okay.
This matter may be listed again tomorrow for passing of the order.
And also, on the last occasion, the victim, since the section 6 of POCSO was also added while while submitting the charge sheet, Your Lordship. They were directed to implead the victim, Your Lordship. They have impleaded the victim, however, steps has to be taken, Your Lordship.
Heard. Order was not there. Okay. Heard, Mr. Learned counsel appearing for the petitioner. Also heard
T. Ginny, Your Lordship.
MST Ginny Learned APP for the respondent. It is submitted by the it is submitted by MST Ginny Learned APP that this year in the instant case is yet to be received. It is further submitted by Mr. So and so, learned counsel for the petitioner, that though the informant victim as respondent number 2 is already being impleaded, there was no direction passed to take steps on. There was no direction passed by this court to take steps on respondent number 2. In view of the above, how do you take steps on respondent number 2? Through
PP's
through
office.
PP's office, right?
Yes, sir.
In view of that matter, the petitioner is allowed to take fresh steps of service of notice on respondent number 2 to the office of the APP
Your Lordship may reflect PP, Your Lordship.
to the office of the PP and the concerned concerned officer in charge of the police station shall serve the copy of the notice on the respondent number 2 accordingly. List this matter after.
Lordship, can it be fixed on 25th?
The petitioner will take fresh steps within 2
Today itself,
uh,
2 days.
Learned counsel for the petitioner will take the steps
By tomorrow.
during the course of the day. List this matter again on
25th.
25th, they said, Your Lordship.
25th.
Your Lordship may also direct for a reminder for the PCR, Your Lordship.
That TCR we have written, the TCR we have been received. Registry is directed to send a reminder for calling of the TCR from the concern. Which court? TCR?
Special court UPI, Your Lordship.
From the special court UPA.
DPO.
Right.
Item number 7.
My lord. Earlier occasion, my lord.
Interim, you have been allowed to go on interim. TCR is received.
We have received the CD, Your Lordship.
Is there anything there?
No, Your Lordship. In fact, the other co-accused has also in their statement not stated anything against the present applicant, Your Lordship. And after the interim bail was granted, he has been cooperating with the investigation.
And the statement also nothing is against it.
Nothing against him, Your Lordship. In fact, he has also stated, though there is an alibi, your lordship will come to page number 27, your lordship,
Page number 27 of the petition.
of the petition.
Yes.
This is a duty detailment register, your lordship.
Yeah, yes, yes, yes.
Duty detailment register, your lordship. Your lordship will find 24, your lordship will find the register's first page, your lordship.
So Mohan Techam, right?
Yes, Mohan Tacha. It's serial number 9, your lordship.
9.
As per his own statement as well as from the record, your lordship, though the incident was alleged to be committed at around 2 a.m., your lordship. However, even this register speaks about he being in the on duty during that period of time, your lordship.
2 a.m.
Yes, your lordship.
2 a.m. on 20. 2 a.m. on
PM, your lordship. I deeply apologize. 2 p.m., your lordship.
So it should be
2
it should be 25th 2 a.m.
2 a.m. your lordship.
So basically during the night of 24th,
Yes.
correct? So you were on duty. Mm-hmm. Page 29. Let's see page 29. Twenty-four to 25. So you were there. What was the allegation against you? 25th of July, 2 a.m. Yes, what happened? Okay, correct. Then checking. So your name was there in the affair? Your name was there in the affair. Let's see the affair. Page 21. It is to inform you that she follows. Okay. Your name is what? Mohan? Mohan Techip Tara. Okay. What was the intention? Was there any dacoity? Nothing. Was there any dacoity? So what was the intention? Hmm. Hmm. The victim is related to these people. I'll pass the order tomorrow. The matter will be listed and I'll pass the order tomorrow. Heard. The learned counsel appearing for the petitioner. Also heard.
TGNE, Your Lordship.
TGNE, learned PP,
Additional people.
learned additional PP for the state. Hearing concluded, order will be passed tomorrow. The matter may be listed tomorrow for orders.
Item number 12.
You haven't filed affidavit for justice service. Like to withdraw this case. What happened? Okay. Mr. Titado, Tada. TATA, Mr. T. Tata, learned counsel, appearing for the petitioner, submits that under instruction from his client, he would like to withdraw this RSA, withdraw this instant RSA number 02 AP of 2025. He submits that in view of the settlement arrived outside court, his client is no longer interested to pursue the matter. Prayer allowed. RSA is dismissed on withdrawal.
Item number 13.
Non-appears on call, list this matter in the next week in the interest of justice.
Item number 17. Sorry, I said item number 15.
Non-appears for the petitioner on call or work. MSP TV, learned APP is present here about this case. List this matter after review.
Item number 17.
Pass it up for time.
Item number 20,
It's for hearing. You are ready? Who will be appearing? He's there online. I can't see him. So. What is to be done? The court cannot wait for him. Is he connected?
No, Lordship.
Okay. Okay.
Earlier also time has been granted. You are MS? MSD ruling learned counsel appears for the petitioner. She submits that learned he submits that Mr. A.K. Purkayastha learned counsel was supposed to appear in this matter in on a virtual mode. However, due to some technical difficulties, he could not be connected today. He could not be connected at this hour today. In view of the aforesaid difficulties, she has prayed for adjournment of the matter and prays the matter to be listed on 5th of September. You are?
And for respondent.
Your name?
K. Lolo.
Mr. So-and-so, learned counsel for respondent number 2 does not have any objection to the prayer made by the learned counsel for the petitioner. List this matter on 5th September. You are also appearing?
I'm for the state lawsuit.
Learned so-and-so for the appears for the state.
Like,
item number 17,
You are agreeable to this thing? Your name? Mr. O. Pada, learned counsel appears on behalf of the petitioner, appears for the petitioner, and MS.
lawsuit, I'm for the state one, but two private respondents also there lawsuit.
Okay.
So his presence is necessary lawsuit.
In the meantime, he can be intimated.
But it can be done.
So once it is sent to the mediation center, they will intimate the counsels. Mr. O. Pada, learned counsel, appears for the petitioner. Mr.
El
Yo
Hage, El Hage,
L. Hage appears for the respondent state,
one,
respondent number 1. However, none appears for respondent number
two.
respondent number 2. The counsel for petitioner as well as respondent number 1 is agreeable for sending this matter for mediation. Both are of the opinion that a resolution can be arrived at if the matter is sent to the mediation. After going through the papers, in the instant case, this court is this court is also of the opinion that the matter can be sent for mediation. Accordingly, registry is directed to send the matter for mediation to your mediation center is there, yeah, here in Itanagar.
List of mediators there.
No, mediator's name I need not give, but like mediation center, you have Itanagar, no? Itanagar, you have mediation center.
The High Court is here.
In the High Court,
We
you
it,
have
we
it, no?
we have it.
Registry may send a matter for mediation to the mediation center located at Guwahati High Court, permanent bench, Itanagar.
Yes.
Itanagar. After the matter is sent to mediation, the concerned mediator may intimate the parties accordingly.
Yes.
Intimate the parties accordingly, giving a particular date. Fine. So after the mediation is over, a report of the mediation to be submitted before this court. List this matter after. How much time usually takes?
Lordship, as per the lordship, mediator, they will,
Correct. So it cannot go on and on. I mean,
in the 3
there
weeks,
has to be
lordship.
some time limits.
3 weeks, lordship.
List the matter after 3 weeks. No, 6 weeks is quite long period.
3 weeks, lordship.
List the matter after 4 weeks.
Okay, lordship.
Interim order so passed in the matter shall continue till the next date. There was some passover.
Passover is not very much, but unlisted is there.
Okay, unlisted members.
Item number 1, unlisted motion matter.
Yes. All these similar matters are different ways.
All the matters are arising out of the same FIR, Your Lordship.
Same FIR. Yes. Yes. Where are you reading? Page 16. Where?
Page number 19 it is in my petition.
It should be page number 19. The FIR format is there from 15. But the relevant portion of the extract of FIR is at page 19. Yes. These four ladies. Yes. Hmm. Your bail has been already rejected by the Supreme Court. 11/8. It was 18. Okay. Which page you said? 32. Yes. Yes. Investigation hasn't started only. Incident happened when? One. It's in very early stage of investigation.
Your Lordship, I'll just, as per the cause list, Your Lordship, I'll just bring out the ground on which each of the accused has prayed for bail, Your Lordship. Accused in item number 1, she states that she is a pregnant lady and she is 4 months pregnant currently, Your Lordship. Item number 2, a 6-month-old child is along with her in the prison, Your Lordship, and it's breast
6 months.
6 months.
6 months.
6 months.
One second, one second. Item number 1, this is,
Pregnant.
she's pregnant of 4 months.
4 months.
4 months. Item number 2,
She's the baby of 6 months.
this is the same FIR, these are the
Same.
4 ladies, right? So, item number 2, what is the ground 6 months old child?
Child is along with her, who is in the breastfeeding stage a lot.
The same jail, right?
Yes,
Sub jail in Rowing.
Roy. And
Then,
item number 3, the ground given is that she's a 65 years old woman and due to all ailments, Your Lordship.
and 4,
In terms of item number 4, Your Lordship, one of her kid has a fractured leg, Your Lordship.
how did it happen? It happened yesterday. How did it happen? These are the 4 grounds.
Yes, Your Lordship. Lordship, at this stage, if the CD is called for, Your Lordship, also the status of, because if such is the situation, Your Lordship, a status from the jail authority, how's the,
Whether the facilities can be given or not.
yes, Your Lordship.
Right, you don't have any instructions on that.
Your Lordship, I don't have any instruction. Since the CD is to be called today, Your Lordship,
Mhm.
I don't have any specific instruction. Also, Your Lordship, there is one eyewitness who has been clearly mentioned in the FIR, Your Lordship. Even if her statement has been recorded by the magistrate or not, that is also to be considered, Your Lordship.
That we'll see when the CD comes. Right,
Yes.
take down in item number 1. The instant bail application under 483 of BNSS 2023 has been filed by the petitioner, namely Srimati Onim Jonki, who has been arrested on 2/8/2025 in connection with the Dambuk PS case number 12 of 2025 under section 1031 in bracket stroke 3 bracket 5 of BNS 2023. And since then, she is in judicial custody. By filing this application, the petitioner prays that she should be allowed, she may be allowed to go on bail. The facts of the case is that an FIR An FIR dated 1/8/2025 was lodged in the office in the office of the officer in charge, Police Station Dambuk, Lower Dibang Valley District, Arunachal Pradesh, by one SI bracket SG bracket close Kenshi Doke. What is SISG?
SI is sub-inspector, Your Lordship.
He is the sub-inspector.
Yes.
By you can write by one Kenshi Doke, sub-inspector. In charge, outpost Paglam, comma, Lower Dibang Valley District, AP, stating that at about 16:30 hours on 1/8/2025, four ladies, namely one Srimati Oyotide Morang, OIYOW TAID Morang, MORANG, alias Pupun, PUPUN, two Srimati Elsa, Elsa Tide, TAID Tide Moyong, 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 three Srimati Haula Tide, HUOLA TAID, Haula Tide, four Srimati Onim, ONEEM, Onim Junkie, accompanied by one Sri Abba Tide, appeared at the outpost and reported that on the same day at around 16:15 hours, the aforesaid four ladies had a quarrel with late Ganesh Dole at the residence of Sri Jitendra Tide of village Paglam, and during the course of quarrel, late Ganesh Dole fell from stairs and died on spot. On reaching the on reaching the place of occurrence, and after preliminary inquiry, it was learned that an eyewitness, namely Srimati Porbadoi Tide, PORBADOI, Porbadoi Tide, stated before the police that, in fact, the aforesaid four ladies had physically assaulted late Ganesh Dole, and owing to which he died on spot. The aforesaid, next paragraph, the aforesaid four accused ladies were detained by the police, which that they were detained Where is the detention order? Is there any order?
There's no order to detention, Your Lordship.
Nothing is there, no, for that in on record. Then he cut it. Detention he cut. They have forced for accused ladies who were formally arrested by the police by the arrest memo dated. All were arrested the same day.
Yes, Your Lordship.
No, detention is fine. Formally arrested. By arrest memo dated 2/5/25. 25. And since then, they have been lodged in the sub jail of sub jail. Since then, they have been lodged in the sub jail of Rowing. Where is that sub jail of Rowing? Is there any mention here somewhere? In the order of the session court? So what is your submission on the alleged incident? Please, the learned counsel for the petitioner submits that the fact leading to the incident alleged in the FIR arises because of the father of accused Elsa type Mr. Colin Tide brought one lady, namely Simoti Koseri Kutum, with the intention to marry her from nearby village on 31/7/2025 to his residence at Gadong village, correct? It was submitted that the lady was arranged by the deceased late Donis Dole. On receipt of the information about the marriage, about the happening of the marriage, about on hearing about the arrangement of such marriage, accused Kola Tide, wife of Mr. Colin Tide, Srimati Onim Jonke, daughter-in-law of Colin Tide, Srimati Oi Tide Morang, niece of Colin Tide, and Srimati Elsa Tide, daughter of Colin Tide. All these four are accused, right? All accused had immediately gone to the Gadum village for a discussion about the matter, and while reaching there, they found the gate and the house locked. After some time, Sri Colin Tide came out and allegedly assaulted Kanong Moyong. Who is Kanong Moyong?
Your Lordship,
Kan-
oh yeah,
Kanan Moyong, the husband of one of the accused, Elsa Tide, with a machete, MSCHETE, on his back, thereby causing severe injury, for which an FIR was lodged at Paglam OP on 1/8/2025 itself. It is also submitted that on the next day, that is on 2/8/2025, another FIR was lodged before the OC police station Mebo, and the injured Kanang Moyang was shifted to hospital for treatment. It is also the case of the petitioner that while the accused Elsa Tide, Oyo Tide Morang, Onim Jongki, and Hola Tide were searching for the omen brought by Colin Tide, they went to the house of Jitendra Tyre, located at Paglam, and found the deceased Dones Dole there, who was consuming alcohol and allegedly drunk. The aforesaid four ladies then confronted Dones Dole Dones Dole about the arrangement of marriage, to which Dones Dole allegedly took out a knife and chased the accused persons. While chasing the accused persons, Dones Dole fell down from a traditional wooden staircase. And later on, he was found dead. It is also submitted by the counsel for the petitioner that where is that have you all reported to the OP? Where? So that is in the affair only, huh? Page. Yes, yes. He submits that the aforesaid four ladies without spending much time went to the outpost at Paglam, no? Outpost at Paglam and informed about the incident. He submits that do you want to say that this is an unintentional kind of thing? It was because of accidental fall or something like that? What is your submission on that? Whether they have killed or what? What is your submission on that? Learned counsel for the petitioner submits that the incident and the death of deceased Dones Dole occurred. No, what did I write? What did you write? Dones Dole occurred due to a sudden fall in the staircase and sudden fall from the sudden fall from the staircase as he was drunk, and due to his old age, he died later on. The incident is purely of accidental nature, and there was no intention on the part of the accused persons to kill the deceased Donis Dole. He further submits that the accused Simoti, the first petition is by Simoti. Apartheid is who?
Apartheid. For Onim.
Huh? Accused person, Onim Jonke alias Apartheid.
No, Your Lordship.
Apartheid alias Onim Jonke.
Apartheid is who has been authorized to file this bail application, Your Lordship. The accused
Okay,
name is
okay,
Onim.
okay.
Right.
Sorry. Accused Onim Jonke. Accused Onim Jonke has been you cut this line, the next paragraph you write. The petitioner, the counsel for the petitioner submits that, as has been stated before, Srimati Onim Jonke is in judicial custody and is lodged at present at sub jail in Rohing. He submits that the accused is going through her initial months of pregnancy, and she is not getting proper care in the sub jail. He further submits that her statements, her statement has already been recorded by the investigating police. Therefore, in view of her medical condition, the petitioner may be allowed to go on bail. This is your submission. It is pertinent to mention, next paragraph, it is pertinent to mention herein that a bail application on behalf of the petitioner has already been moved before the court of the session judge, Anjo / Dibang Valley / Lohit / Lower Dibang Valley / Namsai districts, headquarter Tezu, Arunachal Pradesh, which has already been rejected by the learned session judge by his order dated 11/8/2025. heard the petitioner as well as the learned APP APP submits that at this stage, the bail may not be granted by this court without going to the case diaries. And accordingly, she pays for how much time will it take?
Your Lordship may fix this matter on 27, Your Lordship.
Accordingly, she placed that this matter may be fixed on
27.
27/8/2025. Heard both the parties. This court is of the opinion that the registry may be directed to call for the case diaries.
Your Lordship,
It will be done by the PVP.
that me.
In view of the above submission, the learned APP is directed to produce the case diary on
20.
On 21/8/2000, 27/8/2025. This is the matter on 27/8/2025 for consideration of bail upon arrival of the case diary.
Your Lordship, there's one more prayer, Your Lordship. If the jail authority is being directed to at least give the status report of the health conditions.
Yeah, in the meantime, the sub-jail authority, the authority in the sub-jail of Rowing, the authority in the meantime, authority in the sub-jail located at Rowing shall furnish a status medical report of the accused person. That will do.
Yes, Your Lordship.
So this will be the same kind of order will be there. Only thing is that here your pregnancy is there and other three different grounds were there. Facts will be same. So I will give you those details there in the chamber. Then you can pass the order accordingly. Fine. That will do.
Yes.